Thank you, Madam President.
Surely.
My name is Timothy Biddle. I'm the Director of Legal Affairs for the Howard Jarvis Taxpayers Association. And I'm not here representing anyone in particular. We don't have an attorney-client relationship with anyone at this point. But I would like to make some comments about a presentation that is going to follow mine. I understand Tina Dickinson is going to turn in sworn affidavits from a number of people who claim that their protests were unlawfully excluded because their signatures were, I guess, miscompared by the county. I met with Ms. Dickinson's group. I think they call themselves the Cambrians for Fiscal Responsibility, and they walked me through the numbers, and I reviewed their information, and it does appear to me that the district overstated the number of parcels it serves. I based that statement on a printout that was given to Ms. Dickinson by the district in response to a Public Records Act request. There are quite a few number of parcel numbers that are duplicates on that list, and if you strain out the duplicates, it appears that the district serves many fewer parcels than the official number that the district has been using for determining whether a majority protest was achieved. I also believe that the district failed to take into account that there are at least 100 fewer parcels served by sewer than are served by water, and the district was proposing both a water rate and a sewer rate increase, and yet only used the number of parcels served by water in determining whether a majority protest was achieved. Using the correct numbers, it does look like the community successfully protested the sewer rate increase, even if you exclude the questionable signatures. On the subject of questionable signatures, if those people who have signed notarized affidavits that their protest should not have been excluded because in fact it is their signature on their protest are counted, then it also appears that even the water rate increase was defeated. Legal counsel earlier in today's meeting said that he spoke with the...
Could you just wrap it up, please?
Yes, that he spoke with the county regarding the signature question, and that state law doesn't permit the signatures to be revisited. I do need to correct that for your information. What state law says is that after an election is concluded, a signature cannot be challenged. And the reason for that is that once it's known how a person voted, state law suspects that the reason you're challenging his vote is because you don't like the way he voted. And that's why state law requires that if a signature is going to be challenged, it has to be done before it's known how the person voted. And in this case, where the person's signature was on the protest,
I think
you shouldn't have challenged them at all.
Thank you very much for your comments. Really appreciate them.
Excuse me, I have Mr. Biddle, are you an attorney?
Yes, sir.
Okay. And where do you practice?
Sacramento.
And you came down here?
Well, that's not true. I practice statewide. Okay. My office is located in Sacramento.
And you came down here on your own penny?
Yes.
And just because you're interested in this issue?
Yes.
Okay, thank you.
I have a question as well. I'm surprised that you met with Ms. Dickinson and perhaps some others, but you didn't ask to meet with the CCSd staff.
I would be delighted to meet with your staff. In fact,
before you make these pronouncements,
before I drive back.
As a lawyer, one thing I've learned to appreciate is that there are two sides to every story, and before you make these pronouncements, it seems to me it would be wise to see what the other side has to say.
Well,
Number one.
unless you're calling into question the records that you furnished in response to Public Records Act request, I don't think there's any dispute.
Number two, we didn't invalidate the protest letters. So I don't know why you're making your pitch to us. Well, it seems to me that you ought to be talking to the county clerk.
May I respond? I know my time is up, but may I respond to that
Yes, and
comment?
I'd like the council or members also to, yes, respond and then let's.
The truth of the matter, sir, is that there is no state law authorizing your district to request the county to compare those signatures. Signature comparison is done in an election, but as you know, this was not an election. This was a protest proceeding. In an election, there's two ways to vote. One is by mail as an absentee ballot, and the other is in person. Absentee ballots are signed on the outside of the envelope, and signatures are checked before the envelope is opened. State law says that if the envelope is open so that the way the person voted has been discovered, then you can't disqualify their vote even if the signatures don't match. The same thing is true for in-person voting. If you've ever voted in person, you know that the first thing you do is you go up to the table, you tell them your address, and you sign in. It's at that point, at the polling place, by one of the precinct board members, that your signature has to be challenged before you vote. Once you vote, it's too late, because then state law suspects that the reason the signature is being challenged is because somebody doesn't like the way you voted. In this case, where the protests had the signature on the face of the protest, where it said I don't agree with this rate increase, that person's position on the issue is already known. You can't challenge their signature at that point. There is no state law authorizing a signature challenge in this situation. So all 61 or 80 or whatever it was of those protests should have been counted. But the fact that 40 some odd people have come forward now.
Excuse me. May I, and then you can make your comment.
I'd like to hear what he has to say.
The fact that 40 some odd people have come forward now.
The gentleman has a point of view, and I'd like to hear it.
May I just say this then?
I'm sorry.
The legally, from the board has declared the vote to be did not prevail. Sorry. So I think this is not the venue to discuss whether it's right or wrong. Okay, this is not the venue, because the decision at this level has been made, and the next level of decision is outside of this room. So
you're the president of the board, but I don't think it's a waste of time to hear what the gentleman has to say. He came all the way from Sacramento. He's very well spoken. He's obviously very knowledgeable. I don't agree with him, but he has a point of view. He, for all intents and purposes, sounds like he's representing some people in the community. I think we ought to hear him out, and I'd like to have an answer to my question.
All right, I'll agree with that, but on the other hand, do you agree that this decision will not be changed here during this discussion?
Yes, I agree.
I concur.
Thank you for your time, Madam President.
Well,
Go ahead.
Please, don't
Finish what you have to say.
Well, I was just going to conclude with a request that once you see the notarized affidavits from people who feel that they were wrongfully disenfranchised, that you do exercise your discretion to revisit the outcome of the election and correct it.